This section covers the following: wage garnishment, garnishing your Social Security, garnishing your student loans, collection agency tricks.
We created this video because many do not know their rights. We hope this video helps someone. Check out our other videos. You might find them helpful. The links are in the description. Expand the description and you will see all the links. If you want to know how to file bankruptcy on your student loans, then go to our website.
Please hit subscribe or like. Thank you.
Wage garnishment. It is illegal for the collection agencies to take more than 25% of your paycheck or 100% of the money in your bank account. However, if the garnishment is for child support, alimony, or taxes, then they can take up to 50%. One person we met was out of work for 2 years. When he got a job, put his first paycheck into his bank, they took it all. According to federal laws, this was 100% illegal. But the collection agencies know that most people do not know this, or know how to fight it. Plus, how are you going to fight if you don't have any money? If you make less than $217.50 per week, then no garnishment is permitted, other than for taxes, child support, and alimony. Please see the Debt Collection Improvement Act and the Higher Education Act, Federal Laws 31 CFR 212.8, 31 CFR Part 212, or 42 USC 407A. These laws say that they must leave you money to live on. These collection agencies also know that the company you work for probably doesn't know the law. This is why they tell the company you work for and not you. It is not enough for them to only tell the company. They must tell you before the garnishment begins, or it is an illegal garnishment. These collection agencies also know that most banks do not consult with their legal department and just do what the collection agencies ask. These are just the branches of the bank, and not the bank corporate office. If your wages are being garnished, and you did not receive a notice in the mail before they started to garnish your wages, then it is an illegal garnishment. If it's an illegal garnishment, then the Department of Labor will require them to give you all the money they took and may stop future garnishments. For illegal garnishments, contact the U.S. Department of Labor. www.wagehour.dole.gov. U.S. Department of Labor, Francis Perkin Building, 200 Constitution Avenue, N.W., Washington, D.C., 2021-0. 1-866-4 U.S. Wage, 1-866-487-9243. TTY 1-866-487-9243. Garnishing your Social Security. When it comes to garnishing your Social Security to pay your student loans, will be reviewed in the student loan section. Your Social Security cannot be garnished to pay your debts. However, your Social Security can be garnished to pay taxes or child support. However, there is a loophole that will allow them to garnish your Social Security to pay any debt. The loophole. If you put all your income into one bank account, including your Social Security, then they can take whatever they want out of that bank account. However, if you keep your Social Security in a separate account where no other money is ever deposited into this account except for your Social Security, then they cannot touch your Social Security. For example, if you have one checking account where you have your Social Security directly deposited and then you find $1 on the street, you put that dollar into your checking account, and now they are able to garnish any of the money you put into that checking account. Thus, you need to have one bank account that is only for your Social Security. Plus, you don't have to put your Social Security into a bank account. You can ask Social Security to provide you with a debit card. After you have a bank account that is only for your Social Security, then you need to write the bank and the credit card company and tell them that this account is only for your Social Security. As it relates to the following laws, they cannot garnish your Social Security. Federal Laws 31 CFR 218.8, 31 CFR Part 212, and 42 USC 407A. People have done many of these methods, and the garnishments have continued. and the collection agencies keep calling. All may be illegal, but they know you have no money, so you cannot take them to court. However, if enough people complain, then the U.S. Department of Labor may put a stop to it all. For illegal garnishments, contact the U.S. Department of Labor. www.wagehour.dole.gov. U.S. Department of Labor, Francis Perkin Building, 200 Constitution Avenue, NW, Washington, D.C., 2021-0. 1-866-4 U.S. Wage. 1-866-487-9243. TTY 1-866-487-9243.
Wage garnishment and student loans. For student loans, the best way to stop the garnishment is nothing. There is nothing you can do to stop them from garnishing your wages to pay your student loans, except change jobs or switch your bank account to another bank. In the past, you could go into an income contingent repayment plan, ICRP, and this would stop the garnishment and make you current on your student loans. Plus, an income contingent repayment plan will automatically discharge your student loans after 20 to 25 years. Today, you have to make enough payments to make you current on your student loans, and then they will allow you to go into an income contingent repayment plan, ICRP. If you want to know more about an income contingent repayment plan, ICRP, the benefits, the procedure, please see our video called Stop Student Loans Payments. The link is at the top of this video and in the description below.
Collection agencies' tricks. If you want to stop the creditors from calling without filing a bankruptcy, then all you have to do is send them a certified letter with a delivery receipt stating the following words. A certified letter with a delivery receipt only costs a few extra dollars. I am executing my rights under the Federal Law 15 U.S.C. 1692C for you to stop all communication with me, except for reasons set forth under this law. In addition, this letter is not an acknowledgement that I owe any debt. The part that says this letter is not an acknowledgement that I owe any debt is very important. If you state or imply that you owe the debt, the clock resets to day one. For example, if you owe a credit card debt and you have not paid it for 9 years, then in one more year it comes off your credit report. However, once you state or imply that you owe that debt, then it will not come off your credit report for another 10 years. Just because you sent them this letter does not mean that they will follow the law and stop harassing you. However, with a delivery receipt, you got some proof that you did send them the letter. This will be helpful when you report them to the U.S. Department of Labor for harassment. Another trick that they use is to sue you in court and send you a summons for you to show up in court. Once you show up in court, then they can ask where you bank and where you work. Once they have this information, they can take money directly out of your bank account and garnish your wages. A lot of people have figured this out and now do not show up to court. For civil cases such as this, it is not illegal not to show up to court if you receive a summons. For criminal cases, it is illegal not to show up for court if you receive a summons. If you do not show up to court, all it means is that you will automatically lose. This will also reset the clock back to day one. These collection agencies are now conducting court by phone. These agencies really want to know where you are working and where your bank is so they can take money directly out of your bank account and garnish your wages. If you know you're going to lose, then when the court calls, do not be at home or do not answer the phone. Quick overview on filing bankruptcy on student loans. Yes, you can get rid of your student loans through a Chapter 7 or a Chapter 13 bankruptcy. First, you have to file for bankruptcy. And through additional court proceedings, you may have to prove that paying the student loans will cause you undue hardship, or you cannot maintain a minimal standard of living if forced to repay your student loans.
If you want to know how to file bankruptcy on your student loans, then go to our website.
This does not mean that you have to be disabled. This does not mean that you had to have made a payment. This does not mean that if your monthly payments are zero, you will not be able to get them discharged. Some loans in default may still qualify. Basically, you have to prove that for the next 5 to 10 years, you will not be able to make a minimal monthly payment. Plus, show that 1. You have not lived an extravagant lifestyle while failing to pay the loans. 2. You have not intentionally created your financial hardship. 3. You have not willfully arranged your financial lifestyle in order to avoid your responsibility for the loans. When it comes to discharging student loans, the courts are all over the place. There is no way to predict what courts will or will not do. However, the student loan section will give you some guidance on how to get around some of the tricks that are used to deny you. There was a woman that had a job. Her husband had a job. They had 2 kids and a mortgage. She was able to get her student loans discharged. There was another woman that was receiving Social Security disability for 8 years. She worked a part-time job every now and then. The courts denied her a discharge on her student loans. There is a form called Disability Discharge Application, or Total and Permanent Disability, that will get rid of your student loans if you are receiving Social Security disability, or if you have a doctor saying that you are total and permanent disabled. Most do not know that the government can garnish your Social Security benefits to pay your student loans. However, if you are in an income contingent repayment (ICR) plan, then you should be able to get around this.
If you want to know more about an income contingent repayment plan, ICRP, the benefits, the procedure, please see our video called Stop Student Loans Payments.
Please hit subscribe or like. Thank you.